Now we're going to talk about an area of the law that is very divergent and constantly changing, and the states seem to not really have a unified stance on it as far as their laws and their court decisions. So it makes this area especially hard to grasp and understand. So if I had to pick an area of police civil liability that is very, very difficult to teach, it would be this: civil liability for law enforcement agencies' negligent pursuits and roadside scenes. Because each state generally has different laws and different standards. So we're going to talk in the abstract kind of generalities that apply throughout the United States. But be aware of the general principle that police agencies can be sued for their negligent acts in this area. In addition to the costs associated with injury and loss of life, the use of motor vehicles by police can result in legal liability. Courts attempt to balance criminal apprehension and the potential dangers of police pursuits on a case-by-case basis. So our first topic is negligent police automobile pursuits. And those are analyzed under routine conditions and under emergency situations. When I say under routine conditions, what I mean by that is the day-to-day patrol activities in a non-emergency situation. Like you and I, we all owe duties of care to other drivers. When we get into our vehicle, we owe a duty of care to other drivers, to passengers in our vehicle, and to pedestrians. It's automatic. And if we fail to live up to that duty and we cause damages to someone, we can be sued for negligence. Now, just to review the cause of negligence, and again, we're talking about operation of motor vehicles when performing patrol duties, non-emergency situations. If an accident occurs, usually negligence is the theory against the officer and his or her department. And the department is liable under that concept of respondent superior, which is a version of vicarious liability. The employer is liable for the employee's action. Respondent superior is Latin for let the master respond. And it's deeply rooted throughout the United States. When an employee does something wrong while on the clock, while doing the job, the employer generally is automatically liable for the action if the employee was negligent. Let's take a look at the 4 elements of negligence. We're kind of reviewing this because we've already talked and addressed this, but remember, there must be a legal duty owed. That's beyond, or I should say that's different than a ethical or moral duty. We're talking about a legal duty. Then there must be a breach of that duty by the officer. Causation, either actual or proximate causation of the incident, and damages occur to the victim. So an officer is on routine patrol, and the officer is distracted by the radio, by the laptop computer, or the computer-aided dispatch system in the unit, and is not paying attention, and hits a pedestrian in the crosswalk. That would fall under negligence. There's a duty there. A legal duty was breached because they weren't paying attention. The officer, the driver, was not paying adequate attention, and that caused, and it would be the actual cause of the damages to the pedestrian. Generally, no immunity applies. Lawsuits can proceed. Sovereign immunity applies, meaning the agency can only lose so much money, usually that's set in statute. In Florida, it's $200,000 or $300,000 given the circumstances and the types of lawsuits, combination of lawsuits. But the lawsuit, there's no absolute immunity here. The lawsuit can proceed. Officers are held to the same standard of care as all other drivers. Keep in mind, most jurisdictions recognize the violation of a state or municipal traffic regulation is prima facie proof of negligent conduct, so long as the traffic violation was, or I should say traffic regulation or law, was meant to prevent the damage that actually occurred. For example, if a roadway has a speed sign, 45 miles per hour, and the purpose of the statute in each state of following these posted speed limits is to prevent car accidents, prevent injuries. Vehicles that move too fast are not, you lose a degree of control and ability to control them and stop appropriately and avoid accidents. Well, if a police officer is not on patrol and is racing home after a shift and going 80 miles an hour and hits a pedestrian, the violation of that speed limit, the violation of that statute is prima facie proof. What we call that is very good proof. We can enter that into court to establish negligent conduct because what occurred was exactly what the statute was trying to prevent, the damages that occurred. There are defenses, and as we talked about before in negligence cases, contributory negligence and comparative negligence. If you recall, contributory negligence prevents a plaintiff from collecting against a defendant if the plaintiff is 1% or greater to blame for the fault, for their own damages. That's kind of harsh. I believe only 5 states still use contributory negligence, but keep in mind it basically represents that a defendant can prove in court, bring evidence in court as a defense, and prove to the jury that the plaintiff is 1% or greater to blame for this mess, for this incident, for their own damage, and they get nothing. The plaintiff gets nothing. That is a very harsh doctrine. Most states do not use it now. Most states have converted to comparative negligence defense. Comparative negligence defense is when a defendant who is being sued for negligence offers evidence to the jury, to the fact finder, that the plaintiff is a certain percentage to blame and their recovery should be offset, should be reduced in proportion to that percentage of blame. So a defendant being sued for negligence would bring forth evidence to the jury or judge. If it's a bench trial, we call that a judge, or a jury trial. In negligence actions, usually it's a jury trial. The jury hears evidence from the defendant, and if the defendant can prove the plaintiff is 35% to blame for the damages that resulted, maybe the plaintiff was not wearing their seatbelt when the police officer collided accidentally with their vehicle, rear-ended the vehicle. The police acted negligently, duty, breach, causation, damages, no doubt about it. They weren't watching. They rear-ended a vehicle at a red light. But the occupant in that vehicle was not wearing their seatbelt. That would be a comparative negligence defense. And if medical experts would testify on the stand that the impact between the two vehicles would have never resulted in such ferocious damage to the plaintiff. In other words, the plaintiff would have only had maybe whiplash if they were wearing their seatbelt. But instead, they weren't wearing their seatbelt, so they were thrown through their windshield. Far more severe damages there. Well, the defendant, the police agency, would offer evidence showing that, hey, this particular plaintiff is 80% to blame. for this mess, are 90% to blame for their own damage. Had they been wearing a seatbelt, the damages would not have been this severe. Under a comparative negligence defense, the plaintiff would be reduced in collection, or reduced in the damages they're awarded by the jury in that proportion to blame associated to them. Now, looking at operation of vehicles under emergency situations when lights and sirens are going, presumably. States have passed statutes dealing with the operation of emergency vehicles. Each state statute is relatively a little bit different, but generally the same. It applies to not only the operators of these emergency vehicles, they must act reasonably under all conditions, does not authorize a police officer to initiate their emergency equipment and just drive recklessly. That's not what these statutes allow. These statutes require the operators of emergency vehicles to act reasonable, but it also puts a duty on other drivers, other pedestrians, to give way, to clear a path, to yield to these emergency vehicles at all times when the lights and sirens are activated. Most jurisdictions grant drivers of emergency vehicles limited statutory immunity for violations of traffic regulations during emergencies. So in other words, under emergency situations, lights, sirens, and a pursuit is occurring, or a rapid response to a scene is occurring, there's statutory immunity, limited statutory immunity for violations of traffic offenses. For purposes of immunity, some courts hold that a chase in an attempt to apprehend violators of the law or suspects is not always an emergency. Thus, a police officer's negligence in violating a traffic regulation or law is determined by the circumstances surrounding the use of the motor vehicle and the seriousness of the law violator's conduct. So, a hot pursuit of a minor shoplifter in two vehicles is probably not going to justify the danger that the public is put into, because it's relatively a low-level crime. There must be proof that the officer reasonably believed an emergency existed. That's always a precursor in these situations. Officers are not immune from liability when their actions reflect careless, reckless, or wanton disregard of safety of other persons using public roadways. So activating your lights and turning on your siren and speeding through a school zone when the children are getting out of school and it's visible that there's children all around, that could be a problem. Even though the emergency equipment was activated, there's still liability there due to the circumstances. Courts consider a variety of factors in determining negligent operation of an emergency vehicles. There's justifications for pursuit, actual operation of the vehicle, circumstances of operation, and external factors. These are things that courts look into when they sit in judgment of the reasonableness standard and determining if there is a breach of that reasonableness standard. This is what they look at. So when is a breach of reasonableness in decision-making for a pursuit occur? Well, there are these types of factors. Courts will ask, did a real or apparent emergency actually exist? I mean, first of all, the officer in their mind had to have thought there was an emergency that actually existed. If that's absent, there's big problems. There's going to be a breach of reasonableness. Was the officer's conduct serious? Were there alternatives to pursuit? Often there's aviation departments. I know our sheriff's department, we have 4 helicopters. When a pursuit occurs, helicopters are dispatched. And often the units are told to reduce speed. Let the helicopter chase the suspect up in the air. It's far safer So there's an alternative to the pursuit. And when the suspect stops the car, the suspect bails out, then the helicopter can direct the pursuing officers who are from a safe distance. They can engage that area, set up a perimeter. Did the officer have the ability to prevent the suspect's flight in the first place? And was the apprehension of the suspect feasible? These are things that courts will look at to see if there was a breach of reasonableness in the decision making to initiate the pursuit. I mean, if there was absolutely no feasibility to catch the suspect, why commence the pursuit? Was the officer familiar with the area? That's a big one. Going into unfamiliar areas really can open up an argument for breach of reasonableness in the pursuit decision-making process. Courts look at the breach as to reasonableness and actual operation of the vehicle by the officer, looking towards several factors: the speed at which the vehicle was being operated, the length of the pursuit, the use of emergency equipment. Hopefully lights and sirens are on. I mean, that's going to be a big problem if they're not. The violation of traffic regulations during the pursuit. The following are violating departmental rules during the pursuit. The distance between the vehicles involved in the pursuit. These are all factors determining, or when a judge is trying to determine if there's a breach of reasonableness in the actual operation of the vehicle by the officer. Remember, in negligence, there's duty, legal duty owed, breach of that duty. That's what we're talking about. The court is now addressing that second element, the reasonableness element. Was there a breach? Did the officer act reasonably in light of the circumstances of the environment? That's another twist to this, another analysis. The physical conditions of the roadway, weather, road conditions, and visibility, density of traffic. During rush hour, a hot pursuit probably may not occur, because I know in South Florida where I'm at, and during rush hour, it's deadlock, gridlock. Cars don't even move. But density of traffic, pedestrian foot traffic, neighborhood makeup. These are all things as to the reasonableness of the decision making in light of the circumstances of the environment. If it's rainy or it's a sleet storm, hot pursuit probably is not the best idea and may not be reasonable under those circumstances. A breach of reasonableness in the decision making of externalities. In other words, external factors that courts will take in consideration when judging the breach. What does the department policy state? Does your department even have a policy? That's a big problem if your department doesn't have a policy. That's going to be problematic in court. Was the policy adequate? Were the officers trained in the policy? Was the policy violated or followed? And what was the methods of supervisory control of the unfolding dispute? Were the supervisors just safely tucked away at headquarters and just say, go get them? That'd be a problem. Or does your policy require supervisory authority to commence a pursuit? And supervisors can call off pursuits at any time in their better judgment. That's more of a healthy policy and procedure to have in place. Another area of police civil liability is for failure to arrest intoxicated drivers. This has gotten harder and harder, though, for plaintiffs to prove in court. But intoxicated drivers may cause damages to others. Court developed a common law doctrine through a U.S. court decision in Delahite versus the United States in 1956 case. And we're going to talk about that very important case in just a second. But there are defenses to this type of negligence action. First of all, sovereign immunity doctrines apply. Again, those are doctrines that protect agencies up to a certain amount of damages. Most states limit caps on damages, like Florida, $200,000 or $300,000, given the circumstances and the claims. Some sovereign immunity statutes absolutely bar lawsuits, but most allow lawsuits to proceed under a tort of negligence, but up to only a certain amount of money can be recovered by the plaintiff. This way, our agencies don't go broke. They don't go bankrupt. Think of it, our government is constantly committing negligent acts because our government is made up of people. And if we allowed unlimited lawsuits, no caps on damages, and these sovereign immunity statutes did not exist, our government would quickly go broke, go bankrupt. We as taxpayers would have no government, or we'd be constantly bailing out our government. So these sovereign immunity statutes rest on that public policy of preserving, protecting our government so that it doesn't go bankrupt. Now, an interesting defense, which we haven't really talked about up to this point, is the ministerial discretionary function distinction for immunity purposes. There is a defense of immunity, not sovereign immunity, but it's based on a different principle. And the U.S. Supreme Court in the Delahite case in 1956 announced it. And it's generally been followed and formalized, and some exceptions have occurred over the years through other case decisions. But it really is like a shield or a defense against liability of government agencies by categorizing their actions as either discretionary or ministerial in nature. Discretionary acts are those characterized by a high degree of discretion and judgment involving weighing alternatives and making choices in public policy and planning. When you sue for negligence based on a discretionary act, those acts generally are immune from liability. In other words, we don't want to have to second guess. We don't want plaintiffs to constantly sue and second guess our governmental discretionary actions. As long as they were made in good faith, generally those decisions are immune from a lawsuit. Ministerial acts are operational functions, the carrying out of the established plans and policies. The ministerial acts do not enjoy immunity. So, for example, the actual implementation or the operational functioning of a law enforcement agency, where the rubber hits the road, those types of activities, generally immunity will not attach, and the lawsuit based on a negligence theory can proceed. But if the act in question is a discretionary judgment involved in weighing alternatives and making choices in the public policy and planning, that generally is a great grounds for immunity should a member of the public or other individual sue for negligence. Let's say, for example, a police department outlaws the lateral vascular maneuver, LVM. That's not the chokehold, but the hold to cut circulation of blood to the brain, used by some police departments. Let's say a sheriff's department outlaws, or I should say bars that maneuver, and many do. I know our sheriff's department bars that maneuver. Well, that is a discretionary decision. Policymakers got into a room, they analyzed data, they weighed the pros and cons of use and non-use of this particular maneuver, and they thought it was too dangerous, so they barred it from being used in the force. Well, if a police officer gets into a fight and gets injured and ultimately sues their own employer, and they claim negligence in that decision-making process. In other words, they sue their employer stating that the employer's managers were negligent in creating this policy of barring the use, because the officer alleges if he could have used that hold, he could have prevented the damages and controlled the suspect, and he would not have been harmed, i.e. the officer. In such a case, that negligence action probably would fail because that's a discretionary function that was made, and there's immunity to that discretionary decision. Ministerial functions, though, don't carry such immunity. For example, let's say an officer who uses the lateral vascular maneuver, the LVM, in the field, and he applies the pressure too tight and for too long, and the suspect not only goes unconscious, but then never wakes up, is permanently unconscious in a hospital, hooked up to machines, which can occur under this maneuver. That's a ministerial function, the actual acting out of a policy. That can be the basis for a negligence action. Immunity does not exist there. So if the police officer is sued for use of that procedure, that maneuver, negligence will occur. And of course, the employer will be sued under respondent superior. Now, we've talked about the public duty doctrine. Courts have generally said this does not exist. There's no general duty in which a member of the public can sue the government or law enforcement agency due to injuries caused by third parties. This general overall public duty does not exist. However, under certain circumstances, a special duty could arise due to the relationships created between the law enforcement agency and this civilian, this person. But generally, the public duty doctrine prevents, I should say, the general public from suing for bad policing, if you will. In other words, they're injured by third parties. Maybe they were mugged in the parking lot. They can't sue the police force for failure to patrol the parking lot adequately, or failure to prevent crime in general. That public duty doctrine would prevent such lawsuits. However, if there's a special relationship that's created, let's say that the grocery store hires a detail, a law enforcement officer who's under contract to patrol that parking lot, and that police officer doesn't patrol the parking lot, in fact sits and watches TV inside, and then there's a mugging in the parking lot. Well, public duty doctrine doesn't apply there because there's a special relationship. That police officer should have been on guard doing their duty. Negligence, that's what this chapter is all about in different aspects. And of course, there's negligence and liability of traffic officers if they don't perform and live up to certain duties, such as duty to render assistance, aid, if you will, to motorists, duty to warn and protect if they know of certain severe conditions in the roadway. Maybe a disabled vehicle is stuck in the right-of-way. Duty to investigate traffic accidents diligently to make sure suspects are not floating in a canal off the shoulder. Duty to secure accident scenes so that evidence isn't destroyed, and to prevent an accident from getting even worse. In other words, trying to clear the roadway or mark the accident so other drivers don't crash. The duty to act in such a situation varies from state to state. The duty to render assistance at accident scenes varies from state to state. Where a police officer or agency has the actual or constructive knowledge of potentially dangerous conditions, and that particular officer fails to take reasonable action to correct that existing hazard, civil liability may be imposed. For example, roadside conditions that are known to officers, oil spills, malfunctioning lights or traffic lights, disabled vehicles. There is a duty to act then because the officer, the road patrol officer, the traffic officer is now on notice of these situations. So this whole discussion is really based on negligence and just how far is that duty that is owed to the general public to act and to prevent harm.